Good morning again. Wow, I'm living on the edge of anticipation with emotions going all over the place, advice coming at me from every direction, information that some of which is useful, some of it isn't. But I really appreciate the fact that, well, let me get into the title and the blurb. 2012, a call to action around the world. It's true. People around the world are watching as the bank, attorneys, and court attempt to steal my home without due process of law. There is a remedy that I cannot detail publicly, but I will be happy to discuss it privately with those that may be able to help. It costs $5,000, and it will be removed from the jurisdiction of the local court that is acting in a criminal manner. In the meantime, I ask that people around the world continue to send emails to Sheriff Jack Parker, the man that must make a decision on which is more important, his oath of office or blindly following orders from the corrupt court. His email address is Sheriff Jack Parker, admin at bcso.us. Please be sure to include my name in the email. Thanks. Lots of things to talk about here. First of all, I was really, really pleased as I went through this morning's emails to receive a response back from someone that I contacted yesterday based on the advice of another individual about removing this case to a court that actually weighs evidence and pays attention to the evidence and doesn't just blindly acquiesce to the will of the banks and their banks' attorneys, as is the case with the local court. I mean, I realize after 6.5 years that the local court has no interest or intent to be fair, to even pay attention to their own rules and the laws that govern such things. It is a totally corrupt old boys network, old boys and old girls network of insiders playing a sick game with the public. Now, this is not the only court in the world that's like that. Many of them are. I have written, as you know, to the U.S. Supreme Court and to the Florida Supreme Court and to the U.S. District Court, all of which want me to actually file a thing. And all I was wanting them to do is to put a rubber stamp, as it were, on the writ of mandamus, forcing the lower court to do its duty. But none of them would take that action without me taking further action as far as actually filing a case. And of course, with the U.S. Supreme Court, they pointed out that they hear less than 1% of all the cases that are presented to them. They don't choose to listen to most of them. I mean, it's a very small amount of cases presented to the U.S. Supreme Court that they even hear. So there's no guarantee, even if I were to make that submission, that they would take the case. In any case, I did find a legitimate court that is willing to take the case. Thank God for that. Now, I must move fairly quickly, and it does require a one-time fee of $5,000 to make the transfer. But and I, of course, don't have $5,000, but I'm willing to work with people that are willing to help me in this area. And those of you that listen know that I don't ask for money. I mean, hardly ever do I even mention money, except in the respect that the monetary system is a system of slavery that has been pushed upon the world, and I'm not really in favor of the economic system as it exists. It's not that money is in and of itself anything other than a medium of exchange, but the system is corrupted just as the courts are corrupted. Anyway, the other item in my little blurb is about emails to Sheriff Parker. Now, some people have sent emails, and my name is not even included in the email. Now, I think that he might be able to determine that that's the case, but I'm not sure because you didn't put my name in it. It's important that you put Ron Van Dyke in there so that he knows what case you're talking about. And of course, I have written to Jack Parker and myself personally in both emails and in actual letters in the past. He knows who I am. He's had correspondence with me, although he's never corresponded back. He's received correspondence from me. He's never answered any of it. Now, insofar as keeping his oath of office, there are many sheriffs in the country, certainly not a majority, but many sheriffs who are oath keepers who will not enforce unlawful foreclosure proceedings. They will not kick people out of their homes. And I hope that Jack Parker is moved upon by spirit or in some manner to make that decision, because I have no idea. I've received no notification of what they plan to do, of what I'm supposed to do in light of the action that happened on Wednesday. I did file papers yesterday with the court. You can see it's got the court, it's got the court stamp on it there. It's a affidavit. And I don't know, should I read? Yes, I want the world to understand the scope of this thing. So I am going to take time to read it. But again, I do ask you to continue to contact Sheriff Jack Parker. Anyway, this affidavit is about the foreclosure sale court action on February the 15th, 2012. Number 1, an express mail envelope was mailed to the court at 400 South Street in Titusville on Monday, February 13th, containing an affidavit of negative averment, opportunity to cure, and counterclaim. The item number is, and I included the item number. That envelope was delivered to that court on Tuesday, February 14th, and received by Aaron Guitar at 10:28 a.m. according to online postal records. Number 3, another envelope was sent via registered mail on February 14th containing another notarized original of the same document named in 1. That item number is, and I include the item number. I hand-delivered an unsigned copy to the attention of Kimberly Rosanka at Dean Mead on the afternoon of February 14th, following the registered mailing. Number 5, I personally attended the court action foreclosure sale, also known as auction, on February 15th and witnessed the following. A, this was the first action on the agenda. B, a bid on my property was made by a man later verified as Robert N. Manning from Dean Mead for $100,000 up to $90,000 on behalf of the plaintiff, he said. C, immediately, without allowing any other bids, it was pronounced sold. D, I personally attempted to make a bid for $10 in silver coin, fee simple, real money, and was told, sorry, sir, I said sold. E, I showed him the negative averment shortly thereafter, and he looked briefly at the document and said, I've already seen this. Kim showed it to me. I asked his name, which is shown above in B. Number 6, Mr. Manning represents Dean Mead, attorneys for PNC National Association, PNC Bank National Association in this matter, and not the plaintiffs as misrepresented to the court. And then I provide the web page that identifies who Mr. Manning actually is, connecting him with Dean Mead. That's his. It's on deanmead.com, and he's an attorney, Robert N. Manning. Number 7, I received a return receipt for the express mail envelope on February 15th. Number 8, the post office attempted delivery of the registered mail envelope at 4:58 p.m. on February 15th, according to their online records. Number 9, in the early morning of February 16th, I made a video released publicly on YouTube and Facebook, entitled 2012, When the Courts and Police Break the Law, and then I provide the link for that. Number 10, in the afternoon on February the 16th, I noticed that the registered mail envelope had not yet been picked up by the post office picked up and called the post office to arrange for delivery for today, February the 17th, informing them that your business hours end at 5 p.m., which required an earlier delivery, not when everyone was ready to leave for the day. Affidavit Part 2. Number 1. The court unlawfully failed to respond to my motion to abate vacate order rescheduling foreclosure sale filed on December 9, 2011, and motion demand for writ of mandamus filed in the record on January the 4th, 2012 at 10:04 a.m. And just to clarify that, the order to do the foreclosure sale, rescheduling the foreclosure sale, was filed on December 9th, and I responded on January the 4th, just because so that that's clear. Number 2, the record clearly states that I was denied my rights to due process of law by this court and the Court of Appeal, and was clearly a protest to the order of the court cited therein, as well as the opinion of the appeal court. Number 3, it was filed within 30 days of the contested order, making it timely and requiring attention. Number 4, ignoring this and other of my affidavits and motions before this court constitutes an obvious denial of due process of law guaranteed by the U.S. and Florida Republic constitutions, making the court actions an obvious breach of the oaths of office for the officers of the court involved in this action. Number 5, included in that document was a certificate of acknowledgement of deed in which I acknowledged my lawful ownership of the property that is my registered homestead. Again, it was filed with the court on January the 4th, as shown above. Number 6, on February the 2nd, 2012, I personally appeared before the court to have that acknowledgement duly recorded with the record. I obtained a certified copy of my deed from the court at that time as proof of my appearance. Number 7, this refusal of record is a violation. This refusal to record is a violation of the lawful duties of the clerk of court. However, the 2011 Florida Statutes 695.11 instruments deemed to be recorded from time of filing. Number 8, therefore, I was and still am the lawfully recorded owner of the property in question, and the action taken was in violation of contract and rule of law. The court's failure to take appropriate action prior to the sale was notwithstanding in law, voiding the entire procedure. Affidavit Part 3. I do hereby serve notice that in light of the above facts in this case, Dean Mead, Kimberly Bonder Rizanka, Robert N. Manning, and Clerk of Court Mitch Needleman are now added individually to the affidavit of negative averment, opportunity to cure, and counterclaim as third-party defendants. 2, I further give notice that Sheriff Jack Parker shall also be added should he fail in his lawful duty to protect my rights under the constitutions for the United States Republic and the Republic of Florida. 3, I further give notice that any judge involved in this matter in his or her failing in his or her lawful duty to protect my rights under the Constitution for the United States Republic and the Republic of Florida shall also be added. Final, page 3, demand to court. I hereby, and for the reasons cited in this affidavit, demand a reversal and voidance of the unlawful sale that took place shortly past 11:05 a.m. on February 15, 2012. The court itself, the Circuit Court of the 18th Judicial Circuit in and for Brevard County, Florida, as a private corporation operating under color of law, shall also be named as a co-conspirator in this matter should appropriate action not be forthcoming. These matters are serious and constitute a clear and continued breach of the law of the land. I demand that they be addressed without further delay. Notice to principal is notice to agent, and notice to agent is notice to principal. An unrebutted affidavit stands as truth in commerce. By affixing my signature hereto, I acknowledge that I have spoken and established my truth on and for the record, under penalty of perjury, without malice or intent to harm anyone in his or her natural person, seeking only remedy and justice under law. And I serve this to all the attorneys and to Sheriff Jack Parker, as well as the court itself. Now, I think that's a very powerful document. But I have filed documents that when I filed them, I was so elated because I found the law and I thought, there's nothing they can do about this. This is the law. I mean, it's an open and shut case. And time and time and time again, I've been ignored by this lower court. I have been ignored by the attorneys, especially the attorneys at Dean Mead, or the one attorney that I've had all the dealings with, Ms. Rozanka. I mean, they have failed time and time again. Even in the appeal, they never filed their required answer brief. They never responded to the initial brief that I filed, preventing me from ever being able to file my final brief. So they did stop the appeal process by allowing the judge that I was appealing his ruling to write the opinion for the circuit court, which they unanimously concurred. I mean, this whole thing is an old boys network, a good old boys network, of a bunch of insiders. And bear in mind, folks, as I've said before, but bear in mind that an 801k is the retirement plan for judges. And 60% of 801ks are financed by mortgage-backed securities. So judges have a vested interest in deciding on behalf of banks because their retirement funds are increased by the amount. So they have, and because of that conflict of interest, they have a fiduciary responsibility, if they were in honor, to dismiss themselves from any case having to do with foreclosure, which is why I've worked hard to try to get a court to take this matter and take it out of this jurisdiction, because they don't listen in this jurisdiction. They don't pay attention. They don't do the law. People think that, well, this is what the court decided. It must be right. Wake up, folks. They are doing this not just to me. They are doing this all over the world. And it's time that people take action all over the world. It's time that law enforcement takes action. It's time that the military takes action. It's time that people of character, lawyers that are sick of the system and see the injustices that are happening, that they come out of that system and start working with some of the other courts that have other jurisdictions that aren't involved in this corrupt mess of color of law courts and de facto courts. We need to get back to the law of the land where things can be heard and where every voice can be heard and where people can get a fair trial. That's one of the things. This whole case has been going on for over 6.5 years. It's never gone to trial. It's never gone to trial. There's never been a decision based on an actual trial. They've denied me every step of the way of due process of law. And folks, it's time that we band together. And I am asking people in the local community especially, we need to make a strong stand here locally. I need my friends locally to stand with me and to let me know that you're willing to help. We need some occupying Ron Van Dyke's property, and get the media here and get the people in the local area aware of what's going on, so that any action that the court tries to take will be glaringly broadcast to the public. I don't have anything but my webcam, so I don't have a camera that I can carry around with me. I don't have one of those. I have something that sits on top of my computer monitor, and that's it. So I need help, and I'm asking for help, and I'm calling you to action around the world. Do what you can do. I've given you several ways that you can help, and I'm asking for your cooperation. And I thank you so much from the bottom of my heart for listening again. And I know this is hard for some people because you don't like controversy. Well, neither do I. But we've got to stop the injustice, and we will. Thank you. God bless. Namaste.